Okay, hi everyone. Oh, so I'm right at the back end. Let me just go through today's session. So John Gowing sent me a couple of questions, client case studies, which I had a look at. One was quite detailed. The other one was a really good stock standard one with a couple of twists. And I want to show you a couple of different ways to attack that problem for your clients or for yourself potentially. This follows on from that radical restructure session that we did a few weeks back. So if you looked at that, I'm going to immerse you back into that session. If you didn't have a look at it at that time, then effectively what we need to do from there is just sit back, relax, absorb it, and let's go ahead and have a look at what we've got. And just as an aside, just be mindful on Thursday at 10 a.m. We have our release of our non-foreign purchaser trust upgrades, which is important for any discretionary trust that's purchasing property anywhere in Australia, has to evidence the fact that we need to upgrade the deed and ensure that a non-foreign purchaser is effectively excluded from that deed. Now let's move on. So the procedure for strategy roundtable, well done. You all got your microphone on mute, which is good. So if you want to have a chat at any time, please feel free to either just put your microphone on. Just be mindful of the fact that it does pick up obviously a lot of noise. So if you're in a quiet environment, it's okay, but otherwise just keep your microphone off. If you want to say something, just jump on and say, Grant, and blah, blah, blah. So it's not like a chat session. So it's more like a tutorial, which is pretty important. The session is going to be recorded, so you'll get it a little bit later. So if you don't want, if you're going to ask a question you don't want to show up on air, then just send me a support ticket afterwards and we can cover it in that one. Importantly for this session is you're virtually looking over my shoulder on how I approach a particular issue rather than getting down into the nitty-gritty of dollars and cents. So it's more conceptual because we can go down one way, get into the dollars and cents and find out it wasn't the best way in the first place. So what we're going to do is just keep a helicopter view, have a look over. So this is how I would do it and have a look through things. So stay in your helicopter and not down in the weeds. Now, the strategy roundtable is a great opportunity for us to pull apart a client-specific issue and rebuild it with the goal of protecting families' wealth, ensuring our structure build is safe, secure and compliant. Now, for the most part, it may be that we're setting it up properly for the client, or alternatively, we are restructuring them. Either way, it doesn't make any difference. But those three things are important: safe, secure and compliant. Now, family protection requires, for me, is to focus on defence, not offence. So when you're doing investments, etc., and obviously you're investing for your clients or yourselves, that's not a bad time to be on offence. Whereas when we're protecting something, we should always be looking at our defensive strategy the whole way along the track. It's not the time to go on offence. In fact, it's probably the reverse, because if we do go on offence in terms of our strategy, what we're doing is we're opening up a window to the litigators and regulatory attacks. So our goal there is to really build a moat to protect the family's crown jewels and also their castle. Now, for me, it's absolutely important, and if not, it's vital to lay down the law to the client and make them aware of the potential landmines that are in front of them and strategies, because it's absolutely crucial that they're aware of what is going on and effectively, from that perspective, that they are aware of, because as I said, you've heard me say before, the 4 levels of skills or competencies. The first level is unconscious incompetence. That is, they don't know what they don't know, and that's where your clients are. The second level is conscious incompetence, which is you're at a level and you go and you think, oh my God, I don't know I don't know what I'm doing, and I'm very fearful of it. We spend a bit of time, particularly in these sort of sessions, is looking at how we structure, look at the areas we structure, and more importantly, from that perspective, that then lifts us up to being consciously competent in certain areas. And then when we really know our stuff, we can pull it apart, which is what I'm going to do for you. We become unconsciously incompetent. It's just, well, why do it that way when this way is a better way? But if you don't know which way it is, then it's pretty tough. And I remember, if you have a look at this sort of stuff, it really makes a big thing. I remember interviewing Edward de Bono once, who's the lateral thinker. And we were talking about a whole range of issues, and he gave me a bit of a client. He said, look, when you're looking at clients or you're looking at a strategy, consider an ant. If you told an ant to go up to a specific leaf on a tree, it would be virtually impossible. But if you put the ant on the leaf and told it to get back down on the ground, it would be easy, because it's just simply got to go all the way down. And that's the strength of this, that through this training and through my teaching, you're in a position of being able to effectively get in front of the pack, so to speak. So let's go forward and have a look. Oops, sorry, going the wrong way. Okay, so this is where we want to be with in terms of our moat. So we talk about a radical restructure. It's not really, it's just a different way of thinking. Our goal there is, again, to put a moat around our clients' affairs, so they're safe, certain and compliant and protected from litigation. Now, have I got something that's 100% foolproof? Absolutely not. No one has. The issue, though, is that the bigger the moat, the more crocodiles, the more nasties, the boiling oil that you can pour off from the turrets there, the better it's going to be, because then it prevents the litigators, and particularly the big litigations around for anyone. The big areas are always going to be family law and also family provisions claims. Now, generally, family law is a little bit different, but family provisions claims, generally it's going to be no-win, no-fee lawyers. So they need to build a lot of resources. And if you've got a big moat, then they've got to make sure that they're 100%, because they won't take on a case unless it's a 90, 95% certainty, because otherwise they've got to waste all their resources when they could probably go and get a better client. So that's why we want to build that moat, and we want to build it far and wide and as best as possible. So historically in our structuring, which most of you would have seen, is we've got our little red line there, and the reason I put that there is, for the most part, self-managed super funds are protected from trustee and bankruptcy. So they've got inbuilt asset protection. The way that the bankruptcy laws work, or Bankruptcy Act 1961, is that in terms of a self-managed super fund, and this is problematic, so I'm going to take you through. But in terms of a self-managed superannuation fund, the members' account balance in there, if it's taken out and they're in a pension phase, first off, if they're not in receipt of any benefits, then it's fully protected. So all your super in accumulation, doesn't matter whether SMSF or in a retail or industry funds, all fully protected. If you're in that phase, so you're over 60, you're in that retirement phase, etc., or even if you're taking a tris, if you take an income stream, then that income stream is accessible by the trustee in bankruptcy, because it's just like salary and wages or ongoing income. Importantly, and this is quite an interesting one, any lump sum taken from the superannuation fund is excluded from trustee in bankruptcy. So in essence, if we were broke and we were retired, essentially what we'd do is we'd make sure we only take lump sums. In fact, you could take a $500,000 lump sum and give the proverbial stick your nose up at the trustee of bankruptcy. Now, the only problem about that with SMSFs is that if you are a bankrupt, obviously you're disqualified being a trustee or a director of a corporate trustee, and you can't put in place an EPOA because Section 17A, I think 10, prevents that case. So what it means is if you are bankrupt and you have got an SMSF, then the idea is to put it over into a retail or industry superannuation fund until such time as the bankruptcy finishes. Likewise, with a discretionary trust, we've got a pretty good opportunity there as well. They're built for asset protection. Obviously, tax minimisation is an important point, but once you've got a discretionary trust, the trustee of that discretionary trust, and we've got a trustee company here, effectively holds all the assets of that discretionary trust for the benefit of a range of beneficiaries. So unlike a fixed trust, whereby the individual may have units in that fixed trust, and the same with the shares in the company, if there's litigation or there's a bankruptcy proceedings, then effectively we're basically going to be caught there. Whereas in a discretionary trust, we can, again, that helicopter, you can move across to other beneficiaries and shield the specific individual who might be subject to family law, family provisions, so on and so forth. So in order to do that, we've got to make sure, obviously on death it's not a big issue, but we've got to make sure they're not the appointor, nor are they a trustee. So you want to basically get rid of that. So that's a true family. Again, not a bad one, but again, it's got a few holes. The problem there is you'll find traditionally most estate planning lawyers will take the money out of the SMSF and put it into a will whereupon it's distributed, which is pretty stock standard. And the reason they do that is that effectively they don't understand the self-managed super fund law, and more importantly, what can be done in asset protection, so on and so forth. In fact, you can go from the will to the self-managed super fund, believe it or not, rather than the other way around. So the executor could make a contribution into an SMSF on behalf of any beneficiary in the will, which is not too bad. The problem is once we cross the line, then we're caught. If we go back the other way, we're fine. So this red line seems to be getting bigger and bigger as we talk. So I talked about the weaknesses. Bucket companies, good for tax minimisation when we're obviously getting the money. And the same thing with any operation. Your bucket company is great, or a company's good, but it's terrible for asset protection, tax minimisation for the bucket company, but running a business through a company, is problematic anyway. Trustee companies can be attacked. So going back here, we've got to be very careful to ensure that you use, this is just a basic restructuring rule, that if you haven't got in place our special purpose, or more importantly, the leading member trustee company for SMSF, or the leading member trustee company for a discretionary trust, you need to put those in play because, again, on death, if those shares are held by the individual, or we've got family law or whatever, if those shares are then caught up, they'll be caught up in the litigation or the action, if that makes sense. So if I own all the shares in the trustee company SMSF and all the shares in the trustee company the discretionary trust, and then I go into a family or divorce, or I die and family provisions claim, and there's a challenge there, then those shares fall inside the will or the family law estate or the matrimonial property, and then that now puts me at a serious disadvantage, because a good lawyer or litigator on the other side will pounce on that. I've seen that happen, because effectively what they can do is they can just jump in and effectively prevent anything being done with those companies. And if they prevent anything being done with those companies, then it freezes the SMSF and discretionary trust. And that has its problematic, because then you've got to negotiate from a very weak point of a negotiation. Discretionary trust is good, but again, I find that most of them don't have appointors. I'm getting so many deeds coming up, discretionary trust deeds that go back to the 90s, 80s, even 70s. And really, you need a discretionary trust. Should have been upgraded, post 2012 or 2013, when the Commissioner issued a ruling based on Clark's case and the High Court refusal to look at Clark, that there is no resettlement if any of the provisions are changed, as long as it remains the same trust. So resettlement's virtually out the window. For an SMSF, I looked at one today and did a lot of work on one today, and unfortunately, I'm going to have to sort of skip past a couple of things, because it was a 1996 SMSFD, can you believe that? And they were taking a pension, and the D didn't even allow an account-based pension, because account-based pensions weren't out until 2007. So it's still an allocated pension. Obviously, the client would have breached the 10% or the maximum benefit rule. More importantly, when we had to upgrade the deed or change the current trustee from individuals to SMSFs, it was a pretty daunting task, because the founder had to agree to a change in trustee. It was a really old super concepts deed. It was disgusting, because unfortunately the founder has got dementia. So anyway, we're going to have to work our way through that one. So we really need to make sure when we go through restructuring, and forget about restructuring, is make sure your clients' deeds are all up to date, all their family trusts, all their SMSFs, and then take it to the next level, whether it's a family protection, or importantly, if it's going to be a leading member trust. Now, family provisions claims are nasty, and I'm going to keep on drilling this into you because they are a goldmine. Generally, family law will last maybe 2 years, unless there's a fight for custody of the children or child support. Even then, you're looking at maybe 2.5 years. Whereas the longest legal case that I have seen around family provisions claims or similar sort of claims or elements against a state has been 25 years, and it's dissipated $20 million in assets. It was only wound up because there was no assets left after paying all the legal fees. So where we have fights in this instance, there is no, with the family law court, they'll make sure that you get to a result, and there's mediators, and you get a whole lot of stuff around that. Whereas when we're doing this, it's just open edge Supreme Court work. So you just got to be really careful, and you don't want to be involved. One of the areas I would say to all of you listening is never, ever be an executor for a client's estate. I've seen too many challenges. It doesn't matter what you do. There's potential conflicts of interest, but also there's potential issues that clients will say that you did unfair distribution, so on and so forth. And that will come up in a family provisions claim. So who can make a family provisions? An eligible person, which is essentially a person who is the spouse of the deceased person, anyone who's living in a de facto relationship, and that would include same sex as well, a child of the deceased person, a former spouse of the deceased person. That's damn scary. E is pretty important. A person who is at any particular time wholly or partly dependent on the deceased person, and who is a grandchild of the deceased person who was at that particular time or any other time a member of the household. So grandchildren, so you can see it starts to go down. And even if you're just partly dependent, then you're caught up. Or a person with whom the deceased person was living in a close personal relationship at the time of the deceased person's death. That would include, obviously, brothers, sisters, so on. So really, anyone can get involved in that process, and we've got to get out of that. So that's when we have a look at that, that's what the moat's there. So if I can, there you go. So all these hordes are coming in, all from everywhere, and they're seeking to attack our client's moat. And I'd say the best thing to do is do your own thing. So what's a better way, for me is using a leading member, or if you're using the protector, which I want to look at a little bit later on, using a family protection trust, and making sure that you've got a good line of succession for your executors. Now, here's a bit of Grant's common sense, which wasn't taken to by my family. Mum and Dad put in place EPOAs, I think, it's around about 2014 or thereabouts, when Dad was compos mentis at that stage. Dad gave it to Mum, Mum gave it to Dad, both sought legal advice. And then the three boys were all enduring powers of attorney. why you would do that, and I advised them not to do that at that stage. Anyway, lo and behold, we go down the track. Mum's in a nursing home now. Can't go in, she can't sign documents. You could probably get away with it, but she just doesn't want to see all of this sort of rubbish. So they've sold their house. So this is not basic stuff, but to register the EPOA with the Land Titles Office or the LTO in South Australia, there was one signature missing. And now we've got to go through the whole process of doing it all again, which is going to look at as though it's going to end up delaying settlements. And really, again, this goes down to succession, whether it's in the EPOA, whether it's in the appointors, leading member appointors, or leading member in a self-managed superannuation fund, or in our wills. We need to make sure there's a line of succession that goes at least 3 deep. And my counsel is, don't make joint. Just choose who's going to be the one who's actually going to take control. And for that, I would flip it around on its head and also be aware in an SMSF under section 17A 3B that we all know in our head that all members must be trustees or directors, but that's a lie. It's never been the case ever since that provision was introduced in 1994. Effectively, what happens there is in section 17A 3B, any person who has enduring power of attorney of a member effectively can act as their trustee, or they don't need to be, the member doesn't need to be a trustee. So I had one yesterday where an advisor called up and as a solicitor was putting his son into the fund, had done a bit of research, well done on the solicitor, and introduced the client or his son as the member, but not the trustee. And the accountant said, was that possible? I said, absolutely. In fact, to me, it's probably the reverse way. We want to do it the exact opposite way, that, from our perspective, that look at in our SMSF, our trust, who is the person who has the tenacity, temerity, skills and ability to act as a trustee or a director of a corporate trustee. And if they don't fit the bill, then they shouldn't be anywhere near any of these structures we built, because by that nature we've actually weakened it. It's like putting an extra drawbridge down on your moat. If you've got someone who's weak in there and the litigator can hassle them, that's where the whole thing starts to fall down. And I've seen when letters came from a tax office and went to mum just freaked out, even though she was a corporate director or director of the corporate trustee. So just be very careful. We'd like to restructure, and we're going to have a look at that now. So to me, the new structuring is we still have our wills, but I'm going to show you, I'm going to look at this, this thing from John Gowing. We're going to have a look at this case study around that. Primarily, we have a leading member SMSF, the leading member trustee company. If you've already got a discretionary trust, absolutely go through there, but get a leading member trustee company. And I'm going to have a look at this family protection trust. So where I've got a business running through here, by its very nature, family trust is great, but it's still open to challenge. Obviously, there could be a problem with a business. For example, if I was a butcher and someone got sick, then they're going to sue me. So I've got to be very careful about that, so that the equity or the growth that I build up in my underlying business, effectively from that perspective, is potentially at attack. So I might want to take my growth on that and put it over into a family protection trust. I'll come back and I'll have a look a bit later on. So let's have a look at these facts here. So I've got, John, you gave me 2. Unfortunately, it was just a bit too much to do 2. So we're just going to look at 1 today, and we'll go through exactly what we should be doing. And we might look at the other one early next week, or probably at next week's session, because it's more developed than this. So if we understand this thinking, then we're okay. So we've got Ken and Rose are equal shareholders and directors of Butchery Pty Limited, operating a successful retail butcher shop. So far so good. Equal shareholders and directors, not a big drama there. So there's no joint, so that's a good one. Just as a bit of as an aside as well, just be really careful with your clients when you're coming around to doing property, particularly as they get a little bit older and they've got their family home. I just had a case recently whereby dad was alive, mum had died, they had the family home, dad was on social security, and then suddenly the value of the family home would effectively be in a position of taking them, well, it was going to take them a little bit higher. Plus they had a couple of investment properties. So we've just got to be really careful about joint ownership versus tenants in common. But just be careful about that one. Anyway, we've got 2 adult children. Harry, who's in an 18-month relationship with Sally, as an employed apprentice butcher. So I would say down the track is obviously going to be positioned to take over the business when Ken and Rose want to, go around. And I don't think they'll be cruising around the world. I don't think anyone's going to be cruising around the world anymore. And the other William is single in the army. The problem is William hates Sally. So that's obviously going to be a long-term issue. And as soon as I see that, I think of family provisions claims. I think of, lots of stuff that can go on there. So again, our job is to go on the defense and start to think about what could go wrong. Pretend you're you're assessor at a life insurance company, or an actuary, what could go wrong rather than what will go wrong. And then what we can do is we can then patch it up. So Ken and Rose aspire to purchase the shop they currently lease. Interested in an LRBA via a new SMSF, which is fantastic. Good on them. They have significant equity in their $1 million home with only $200K mortgage. They've got old wills executed prior to the children being born. So that's we've got a good stock stand. So we've basically just got a company. I've got kids now who are obviously adults, and we've got a couple of really old wills. So traditionally, I'll go down and have a look at this. So the suggestions here from John: prepare new mirror wills for Ken and Rose with reciprocating distributions on death of the first to die, death of the survivor, providing for a testamentary trust for each primary beneficiary for the 2 sons, which is A-OK. Shares in butchery proprietary limited pass to control from the survivor to Harry if and when he finishes his apprenticeship, which is okay. And then prepare BDBNs to be signed once the new SMSF is established with a corporate trustee. So I'm going to show you 2 different ways that I would handle. I'm going to bounce out of here. Again, I'll just go out of here. And then I'm going to show you the moat. So what I do is when I look at the moat from my perspective, I'll just go up here. So what I tend to do, I'm going to build a new one for you. I think I've got enough. Yeah, I've got enough time to do both. So traditionally, what I'll do is I'll go in and just build a moat for a client. And if I just do the moat, so rather than doing any of the individuals, so you had it there, so you can see here it's the moat. So I'll start the document and I'll do a folder. So what I'll do is I'll put it into my Abbott test folder and I'll start, and I'm going to call it the Ken and Rose moat, or the KR moat. So I just want to go through and show you how we would do it from a perspective. So I've got the KR moat. And then obviously because there's legal stuff in there, use the Abbott-Family logo. Now, the documents, what I'm going to do here is I'll just do them, I'll assume they're in New South Wales. And then what I want to do is we haven't got a corporate trustee or, okay, so we'll do a leading member SMSF establishment and a leading member SMSF corporate trustee. What I'm going to do is, I'll show you anyway what to do, and I'm going to drop it off. So because they haven't got an SMSF, I would do that. Now, I've also got these abilities. If it was a different client that already had an SMSF, then you can upgrade your constitution to a leading member one and upgrade the deed to a leading member, or you can just do your plain basics. But look, if you're moating, you go leading member. Do an SMSF Will, which is a fancy set of binding death benefit nominations, and then we've got our last will and testamentary trust, because we put that in. Now, I put that in and I can always change it later. Now, as you're producing it from data, and again, probably something this big, or this one's not too bad. We don't know what the date is, but let's just say we're preparing it on the 25th. The name of the accounting firm is Super Accounts Pty Limited. So we put that in there, and so that's not too bad. So they're all the documents I'm going to do. Now I'm going to go to common parties. So this is like our CRM. So I'm going to put this all in there. So I've got Ken Butcher. Bitcher. Thinking my dog's Butcher. And then we're going to 5 Smith Street, Fairlight, New South Wales 2095. So that's Ken. So I'm going to do another one now. I'm going to do Rose Butcher, and I'm going to do 5. What did I say? So I can't even remember. 5 Smith Street. 5 Smith Street, Fairlight, New South Wales 2095. So far, so good. Now I'm going to add another. So we've got the 2 kids. Did we have their name? We did have their names. So sorry about this. So we've got William and also Harry. Oh, I should remember that one, shouldn't I? Really, good naming protocol there. So I've got William Butcher, and he's at 100 Smith Street, Manly, New South Wales. Oh, sorry, Manly, New South Wales. I think that's 2094. I remember if I lived there before. So Manly. Add another. So I've got William, and now I've got Harry Butcher. Now I'm not going to put the girlfriend in at that stage. It's only 18 months, and it's just too much. And I think Harry was Harry's and Williams are one in the army, obviously. So we're going to go down 100 Brown Street, Manly, New South Wales, and that's 2094. So everything's so far so good. That's all my common parties. Now, if it was a bit more advanced for your clients, you would go mum, dad, all the kids, even the rehab ones or the black sheep, because we can deal with them testamentary trust. And then what we would do is we would also include grandchildren there if we want, if they're going to be part of specific gifts. So we've got all that. Now I'm going to do the enduring power of attorney. So I've got the principal. So again, I'm going to do everything here. So this is a pretty short timeline to get all this done in 2 days. So I've got the old Ken, so that's okay. Now the attorney, we're going to make it obviously Rose at this stage. Substitute attorney. Now this is going to be interesting. Now we're going to have to chat with the guys and say, look, who's the best for us? Because we've got Harry and William, and then those 2 essentially don't like the spouse. And I'm reticent of the fact, particularly making both of those guys enduring powers of attorney, because if they're fighting, it's going to be dangerous. So they're going to have to choose one of them. So given the fact that Harry's the butcher, then I'd actually make him the next one, because essentially most of the assets are potentially there. I could add another, but I don't want to go down that enduring field anyway. So let's go and have a look at the questions. First off, will the attorney, for example, Rose and then Harry, act on behalf of the principal for the super fund, including as a replacement trustee or director? I would go yes for that one. Do anything on behalf of the principal? Yes. Act as an alternate director where the principal's the sole director. So at the moment with the butcher shop, they're not a sole director, but I'd still put that in there as well to cover that, just in case something happens to Rose. So when will the power of attorney commence? Upon signing the document. Do you want to revoke previous appointments of attorney? Yes. So many I don't see do that revocation, which means the earlier one is still in there. Because it's New South Wales, Section 19 requires a solicitor sign off, so good old Tony from Abbott-Family will sign off, so we do that. Now, some additional powers. Authorise my attorney to give reasonable gifts as provided. Well, it's up to you. You just cover the client for that one. Authorise my attorney to confer benefits on the attorney to meet their reasonable living and medical expenses. I'll probably say no to that one. Authorise my attorney to confer benefits on such and such a date, meet their reasonable living, and leave that one a blank too. State additional powers and conditions, limitations, etc. So we won't go there. Now, with a company, we remember this is the business company. So it's a butcher, Pty Limited. I put in the ACN, current directors' names. We've got Ken Butcher, and then we've got Rose Butcher. And what that does, that throws up a set of binding minutes for alternate directors. So the SMSF, so this is a new one. So it's going to be the Butcher Super Fund. In fact, what we might do, we might make it a family one. The Butcher Family Super Fund. So that's okay. Registration. So which state it's going to be registered in? New South Wales. Company details. Use a new company name. So what I would do is, so that's Butcher, Pty Limited, registered office, we can just go there, 5 Smith Street, New South Wales, 2095. Obviously, if it's your accountants, you'd put it in the accounting registered office. Does the company occupy these premises? Yes. Is the registered office the same as the principal? Yes. Company associates. So if we have a look, select each role held by the company. So now remember, this is the corporate trustee of the self-managed super fund. So what I'm going to do is director and secretary, and I'm going to put in here Butcher, and I'm going to put Ken, former name, not thing. Is the address same as the registered office? Absolutely. Date of birth, 20th/04/1971. So that's okay. Country of birth. I'm going to come back and tell you what I've done in a second. So state is New South Wales. Place of birth, Dubbo. That's a nice place. Okay, now I'm not going to add other company associates, and the reason I'm doing that is for that succession. Remember, if we go back to here, if I'm doing a leading member and I'm doing it this way, and I want to pass the shares from one to another on my death or my resignation, then effectively what we want to do there, and the next person in line anyway is going to be Rose. So that's not a bad thing. So what I'm going to do is just here. Now what it'll mean though is Rose is a member of the superannuation fund, but she's not going to be a director of the trustee. So when I come down to the share allocation, this is important. We've only got one person, the leading member. So the share class, the only one we've got is non, which is non-dividend paying. So we'll go 100 shares, amount paid for the share, dollar, amount unpaid is 0, sorry, 0, 1, are beneficially held, yes. So that's okay. So the chairperson, oops, so what have I done? So that's okay. So sometimes if it doesn't work on the left, you have to just press on the right. Actually, it's probably not a bad idea, saying I've got so much as to save the answers so I can get it in progress. Because when you're doing something like this, it's a big one, but it's good. So we've got the chairperson. Who's a public officer? We've got the old Ken. Who's going to sign it? Ken. Is there a second person signing? Nope. So the members consent. So so we're going to do this on the 25th. Members there means shareholders. So it's just a quirk of the Corporations Act. Directors meeting, which is fine. So I'll put in the minutes. Do you want to make changes? Standard minutes? Nope. So if you have a look, you're going to get the leading member minutes anyway. So where am I up to? Leading member. So now we're getting in the leading member of the fund. When's it going to be set up? It's going to be set up on the 25th. We're going to do it in New South Wales. Trustee versus corporate trustee. So what I've got now is Pty Limited, and remember it's Butcher. I haven't got the details yet for the ACN, so that would come in. But let's say that we've got. In fact, what I'll do is I'll leave. Let me put that in. In fact, what I might do is. Now that I've got this, I've got the ACN, it's all done. So I might go back in here and I'll add another common party. So I'll put the company there and I've got Butcher, Pty Limited. I've got the ACN back now. So we've notified you what the ACN is. I know it's 5 Smith Street. Fairlight, see me, 2095, and there's one director there. Remember, this is the family, this is for the superannuation fund. It is not, what am I talking about? So Ken Butcher. So this is for the superannuation fund. It's not for the business. So I've done through the corporate trustee. I've got the trustee here. Of the SMSF. So I've got the, sorry, where am I going here? So general corporate trustee, leading member SMSF. I would just select the party here and that populates everything. Can you see that that's done that easy? The leading member, is the leading member a joint leading member? No. Remember what I said? So I want to go Ken first. Do I want to have a second one? Yes. So who's that going to be? So the second leading member. Is it a joint? No. I'm going to make that row. So I could go if I wanted to. So I'll go to the third one. Yes. And that's going to be Harry Butcher. And Harry is 100 Brown Street, Manly. So I hope you're with me here. So I know it's a bit of a thing, but we're getting there. So into the members' details. Third leading member. Manly, New South Wales, 2094. So again, can you imagine how many, do I want a fourth one? Can you imagine how many documents I'd have to go in and out of the system, which is perfect while we've got that. So we've got the member here. So who are the members' details? I've got Ken, add a member. I've got Rose. I'm actually going to add in there as well. I'm going to add William. But William, I haven't made as a director of the corporate trustee. Now, I can go back at any point in time and change it over if I wanted to, but it would mean that Ken has William's EPOA. And you can just do it for SMSF if you want. Trustee of an SMSF, So we put that in there. We've just remember we put that in pre-filled it in. Okay, so now we get down to the SMSF Will. So I'm going to do this. I'm going to do all this for. I might leave this for later, mainly because we haven't set up the SMSF yet. So we need to get all our money in. But I'll just do it indicatively. So the nomination. Do we want to revoke earlier? Yes. Does the member want reversion of pensions to take precedence? Yes. Does the member want to appoint executor as a replacement trustee or replacement director? Yes. Does the member want death benefit payments, including pensions and lump sums? Yes. Does the member want a professional look after your estate, which is you guys? Yes. And if the whole fund is stuffed, it's non-compliant, do you want to catch all? So that's like the nuclear option. Then you go yes. So we then go down to death benefit payments. Does the member want to nominate the beneficiary of their estate? Now, if you did that one, you're not in Grant's crew. So, the beneficiary there is going to be Rose Butcher. She is the spouse. Now, what I've got to do here is I'm going to have to make a decision that I'm assuming the property is sitting inside the fund. So all interest that my superannuation interests have in the butcher shop at 5 Smith Street, Fairlight, New South Wales, 2095, if that makes sense. So what's happening is effectively that's all being passed to Rose. Now, it's probably better off if there was a pension there anyway that did that. Now, if in the event that Rose isn't there, then because it's the butcher shop, what I'm going to do is send the rest over to Harry Butcher. Now, in the event that both Rose and Harry aren't alive, then I've got two choices. It goes to the deceased estate for the sole benefit of the deceased bloodline or lineage, or the deceased estate for the benefit of their family, estate, beneficiary and charity, unless an SMSF death benefits can be trusted. I'd probably go there because what will happen is then William will get it by way of a SMSF death benefits trust. So whoever's running the fund will be fine there. So she's to get all the stuff. I can add another now. So the beneficiary I can have here, let me say that I'll put William in here. William Smith. Remember, he's the one who hasn't got the business. The remainder of my superannuation interest, excluding the butcher shop property. Okay, I think this is being recorded, eh? Now, in the event the beneficiary is not alive, then it is to go to William Smith. And again, we'll send it through the Death Benefits Trust. Oh, so William, we send it to, Harry Smith. Now, that to me, that's a good, strong SMSF will. It's not it's not rubbish. Now, the nominated professional there, we can put the party in, but we're going to put, remember, John Accountant. Normal partner, legal, what's a normal partner? Normal partner, administration fees. Sorry, administration, there we go. So we have to put our fees in there because this is a binding contract. The firm name, remember, was Super Accountants. Pty Limited. Street address 5 Street in New South Wales 2000. Okay, so then we go down to the meeting. It's going to be Ken, select the address. We're going to just go 5 Smith Street. I'm going to leave it unknown because, again, I haven't set up that self-managed super fund. Remember I did that. Now I go to the last will and testamentary trust. So that's okay. So again, is there a life interest? So that's for the property. We'll go no. Date of the will, I'm just going to make that the 25th. Testator there is going to be Ken Butcher. And then who's the accountants? So again, the accounting was Super Accountants, Pty Limited. And it is important to, I don't think anyone else does this, but certainly it's important to have your names all over there because you can then administer the estate, because otherwise the slimy lawyers try to get involved there. Okay, so the executor, remember Ken's dying, so the first one is going to be Rose. Now it could be Rose or it could be William if we wanted to. I think he's the one I've got to keep on remembering. So I keep on forgetting who the right ones are. So here we go. Okay, so Harry's the butcher. So be Harry. So let me just go back here. Probably save it again because I haven't saved for a while. And then I'll go down here. So I'm not going to have a joint. I'm going to have a successor executor. I'm going to make that Harry. And then that's okay. I could add another if I wanted to, but I'm quite happy with that one. Specific gifts. Is there a specific bequest? I would go yes. So the first one, who's actually going to bear the expenses for the gift? It can either be the estate or the beneficiary. Let's just make it the estate. Now the gifts. Okay, so what we can do here is we can, who's the beneficiary? So if we have a look at it, we can put Rose Butcher. So she is the spouse. The asset there is all is in, I think it was the Butcher Pty Limited. I think I need to change that. So you can see as I go through, I'm just laying it down. I have to go back and check because I've got the trustee being Butcher. Yeah, so that's okay. I've just got to watch out for my actual shares of my business. So I'll just put Butcher Business Pty Limited. Now, do you want this asset to go into a testamentary trust? I would go yes. Is the gift automatically transferred to the testamentary trust? So this is optional. I can either put it or not. I go probably, I don't know. Let's just go yes. Do you want the second beneficiary to be yes, bloodline or lineage? That would be yes, because the next beneficiary along is obviously going to be Harry. Are there any related entities, such as bucket companies? At the moment, we'll say no. Is the primary beneficiary the appointor? Yes. And then any other further terms or conditions? The death, demise, incapacity, or resignation by Rose Butcher. Harry Butcher is to become the appointor. Both Harry and Rose as trustees of the testamentary trust. Now, what will happen is once we do this, it's your job to then go through the process of building that trust. I mean, it's built into the will, but it's not a full trust. You'll need to build that on a thing. Social media, well, probably no. I mean, I can't imagine. Well, you never know, actually. So there might be some social media accounts. We'll pass that on to Harry Smith. You never know. Ken the Butcher might be a bit of a star. So principal beneficiary, let's just go to Rose. She's the spouse. 100%. Now, if she's not alive, then her share of the estate. So remember, there's a specific gift which is already happening into the testamentary trust. Now, if she's not alive, obviously what will happen with that specific gift? So if I go down there, all the shares go into the butcher business and that thing. If she's not alive, then that lapses, and so that'll go into the estate. So what we want to do is the same sort of thing. We want to go through, we can put it into a testamentary trust, but remember, if she's alive, then it's only anything other than those shares. So I'm not going to put that into a testamentary trust, but I have got to think about what's going to happen. So what I'm going to do is I'm going to pay it to my secondary beneficiary. And my secondary beneficiary is going to be, who do you think? It will be Harry. And that is the son, 100%. Now, if he's not alive, it goes to the tertiary beneficiary. Do we want to go into testamentary trust? Yes. So is the main estate beneficiary a secondary beneficiary, the testamentary trust? We go no. Is a spouse to be included along with the main beneficiary? I would say that's up to whether we want to. Obviously, if it's the 18-month girl, we go no. Secondary beneficiary, bloodline or lineage, yes. So that could be his kids or it could be wills. Any related entities, no. Is the main beneficiary the appointor? Yes. So I'll just leave it at that. Now, if they're all toast, then what we do is we just give everything to William, the army boy, and that could be the son. Now, again, remember what we're doing there, 100%, and then if no one's around, then we just go to the bloodline beneficiaries. We could do testamentary trust, we'll go no. Remember, we're doing all this and sending it to the client in dribs and drabs. Is there a guardianship? Nope. A pet guardianship? Nope. Funeral wishes? Yes. Scattered off the beach in Manly, New South Wales at sunrise. So on my birthday. So that's okay. So we do that. So we've got that. So that's our documents. That's a big enchilada. But what I would suggest is I haven't got time to go through. I'll just go through what the documents look like. It's going to take a while to render because there's so many of them. But what I would do is for every client, I would be setting them up in this way, particularly if they've got a self-managed super fund. Now, you're not going to do all these documents and give them to Ken and Rose because otherwise it's just going to blow their mind away. So you start off, what I would do is chop up the package. And so we've got the comprehensive estate planning package. We've got a letter here from Abbott and Morley, which basically says that all the stuff has been based on a data capture from super accountants based on Abbott-Morley precedents. And so there's no legal advice. They're not holding themselves out as experts. And then we go down here and obviously there's a bit of an issue there. I've left something blank. Then obviously with the wills and power of attorney, again, that's just an execution stuff there. So I've got the enduring power of attorney here. And what did I do there? Okay, so you can see when you've got that, obviously the postcode is missing or there's a coding area there. So if you ever see that, please get in touch. I know, John, you did that for me and that's now been fixed up because then we can fix those sort of things up. So I revoke any previous, authorise my attorney to, on my behalf, to anything they can do, act on my superannuation fund and also act as an alternate director. So when we go down here, we also find that it's signed by the old Ken Butcher. Tony and Wills will come in, so you just have a Zoom meeting with him, and he has quite a few of those. And then what we do for that one is that essentially he'll sign off on that. It's all legal and so on. All the attorneys sign off as well. So that's both Rose and Harry. we go down and we probably give that. And this is a resolution by the company to appoint an alternate director. This is where your enduring power of attorney sits in. So that would work for and this should have been the butcher business. In fact, I think I've probably made a mistake. It should really, because that's the superannuation fund, it should have been butcher business. So that was my fault, but that's easy to rectify because all I have to do is just go back in here and go into my vault. You go into Abbott test. I think I did Abbott test. And then I go down to the KR Moat. I'd open it up. And then I would go down here. So just opening the whole thing again. And so then I'd go down to the company. So I go butcher business. And then all I'd have to do is save that or just finish, and that's it. So the next one I came up with would be okay. So again, that's how easy it is to change these things. So we've got the leading member SMSF deed, the establishment of the Abbott-Family SMSF. So we've got all that. Abbott-Family Super Fund Trust deed, leading member. I'm not sure why that didn't come through, but I'll go back and have a look at that after that one. So I must have made a mistake, or there might have been a glitch there, because you can see, well, obviously there's a glitch because a couple of times the postcode hasn't come up. So we go through there. We've got all the different leading members: Rose Butcher, third leading member Harry Butcher. Then we go through all the provisions, executes the deed. So you've got the leading member there. So obviously there seems to be a coding area there, which I'll go back and change straight after this. And then we've got the deed and the governing rules of the Abbott-Family Superannuation Fund. And I think you're going to find this is probably going to be like 5 million pages, the whole document. So I'm going down to getting close here now. Okay, so that's the end of that. I've got the SMSF Will, the Abbott-Family Superannuation Fund for Ken Butcher. So that's your PDS there. And we just go through that whole aspect. And then we've got here the application by Ken Butcher to the trustee of the fund to accept SMSF Will. We've got reversion. We've got revocation of earlier BDBNs, reversion pending to take precedence, appointment of replacement trustee and member, and then we go through Rose Butcher, death benefit payable, all interest that my superannuitors have in the butcher shop at 5 Smith Street, and importantly, all throughout a superannuation fund, you can see this benefit may be paid. So we leave that as is, may be paid as an income stream if allowed under the superannuation laws, which would be if it goes to Rose, or transferred directly to the designated beneficiary, which it could, or any trust, company, person, or other entity the beneficiary directs. So it could go back into that a leading member of Family Protection Trust, including a transfer to the deceased member's estate for the asset to be held specifically for the beneficiary or in a trust for that purpose. At the direction of the beneficiary or any leading member, the trustee may create an SMSF Death Benefits Trust to hold the designated bequest. The SMSF Death Benefits Trust is a discretionary trust whereby the beneficiary of the assigned is to be a trustee appointor, and it goes on and so forth. If Rose is not alive, then it goes to Harry. If they're both not alive, then it just goes to bloodline into an SMSF Death Benefits Trust. Son William Smith, so he gets basically everything else except the butcher shop and property. Same sort of thing there as well. He's not alive, so on and so forth. Nominated professional is John Accountants. And then we sign it as witnessed twice, and there's a binding resolution to accept it by the trustee of the fund. And again, with that binding resolution, you could just have the chairperson, but again, safe, certain, secure. We actually put all the details of the member and the trustee and the acknowledgement there as well. And then we go to the last will and testament. So there we got this will is made on the 25th of June. appointment of executors, so it goes Rose, then it goes to Harry. Ongoing trustees are going to be the executors. Provision of advice is that super accountants again. Remember, we want them to be involved in the estate. Initial administration is calling debts on. So these are the beneficiaries: spouse Rose, son Harry, son William. So when we go down here, in the event that Rose Butcher survives me by more than 30 days, all shares in the Butcher business, this entitlement to be automatically transferred into testamentary trust with the following conditions. Beneficiaries will extend the primary beneficiary's bloodline or lineage children. Rose Butcher is the appointor and able to choose any successor appointors. Rose Butcher is the trustee. In the event of the death, demise, blah, 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 then both Harry and Rose will act as trustee, but Harry's to become the appointor. So she's able to choose him at any point in time anyway, but we're putting in a secondary thing. Social media accounts go to Harry. Now, principal beneficiary is Rose, but if she's not alive, then it's to go to the secondary beneficiary. If no one's alive, then it's to go to all the bloodline. Secondary beneficiary goes down to Harry on a testamentary trust, which we did. It's all those T's and C's. Now, if no one's alive, second beneficiary, then it goes to William. And if William's not alive, then it goes to all the bloodline. Funeral, it goes off to Manly, so on and so forth. So that's the, let me just see. So that's the will. And it looks as though we've got a company at the back end. So this is our leading member constitution. Probably should have been up front, but it's not a bad idea. So you can see here, there's the leading member constitution there. We just haven't simply got the ACN, but it's got all the corporate management, who's the tax, so on and so forth. Share certificate. So you can see there, it's a pretty, remember we didn't have the director's meeting date, so obviously it wasn't put in there as well. So you can see there, that's the comprehensive estate plan, and I would use that for each client, particularly because all of you are on we're all on subscription. So you put it all in. Now you're not going to go in and give all of that to the client. What I would do is, if I just go back up here into my strategies, into my vault, and I'll show you. So I'm going to go Abbott test. Just this little quick thing as well in your Moat package. You can see here, see this little one on the right? This actually tells me, if I go in that, all the times I've actually started this document with a subscription and amended it. So what I do is I can go in here and probably, just to start off with, what I would do is, and you're not going to lose any information. This is just a bit of a hack that I use personally. The reason I build it with such automation is because we use it at Abbott-Family all the time. So you guys are getting a huge benefit there. Look, no other legal firm in Australia has this sort of stuff, let alone anyone else. So I still do the EPOA, but I'll probably just turn those off at this stage. Turn off the SMSF Will. I'd leave the last will and testamentary trust, still leave all that stuff as well. So just focus in on that. So, and then once I've done that, then I can come back and do the leading member SMSF establishment and the corporate trustee and the SMSF Will. So break it down into little bits so the client can digest it. But as I said, if you wanted to, you get it out to them in 2 days flat. So probably I would say it's not a bad idea not to send them out in draft and get them to come back, because that can take some time. It's better to probably bring them in for the next meeting, show them all the documents. If it's right to go, then it's right to go. If you need to have a meeting with, or Tony to do the execution, do it at that particular point in time. But what I'm going to do is next week I'll come back to the other sessions that John had. All of that stuff is the same and it all fits within there. But what I would do is I'm going to roll in, I'd actually do a protector there and put all the equity of the value of the shares into a family protection trust. Then if I did that, that's a better way. So next week I'll come back and we'll go through a review here. If you want, jump back on again, have a chat with Sophia, come back on. Any questions that you have, if you could shoot them through to Sophia, and then what we can do is I can then address those questions next week. I'll go and build a protector, and then we'll fix everything up from there. I'll go through and then show you how to do the protector. And I'll look at that other session of John. So that'll be next Tuesday, which I think is the 30th of June. So what a way to finish the end of the year. But if there's no other questions, if there's no questions, I'll just jump off. I'll record it and shoot it off to you very shortly. So thank you all for your time today. It's quite intense. But again, once you do one and get that common party in, start to build it, watch this a couple of times, you're going to move from unconscious incompetence to conscious competence, and you're going to be well in front of any legal firm around Australia, and you're going to be really great motors and great succession, asset protection and estate planning advisors. Anyway, it's Grant Abbott signing off.